Good afternoon. So we start the after lunch session, which is always a challenging session to be concentrated after lunch. But I believe that the panel of judges that we have present here will make it so interesting that you wouldn't have any problem in concentrating. And we have 4 judges who will intervene in this panel. We have first, I'm just following the list, first Judge Ivana Jelic from Montenegro, who will join us online. Then Judge Arnfinn Bartsen from Norway, also president of section. Judge Jovan Ilievski from North Macedonia, and at the end, Judge Tim Eike from the United Kingdom on very interesting topics. So we first start with Judge Jelic on lockdown measures, analysis of the relevant European case law. Hopefully Ivana is connected. Yes.
Yes, I'm here. Hello,
Thank you.
everyone. Yes, it is my great pleasure to be here, or actually to be with you today, although online, due to other conflicting obligations here in Strasbourg. And I hope that forum is going well. As I can see, the atmosphere, I can imagine, is excellent. Today I'm going to just address lockdown measures, analysis of relevant European case law. And for the beginning, I would just like to emphasize that the 2020 pandemic and the unfolded public restrictions had multiple fallouts on human rights as many states grappled to contain the spread of the virus with restrictive measures. European states' response to the pandemic varied across the continent. By way of illustration, Swiss and Slovak national authorities quickly reacted by closing all shops, restaurants, bars, and schools, prohibiting public gatherings, and recommended that all citizens stay home. Some more targeted measures were, however, much more contentious. For instance, Maltese authorities have defended the controversial offshore detention of more than 400 people in 2020 as a public health measure in response to COVID-19. Being nationwide, localized, and tailored to a specific environment, lockdown measures pose 3 main legal issues to the court, 3 main legal challenges to the court in Strasbourg. First, applications containing lockdown measures challenge the court's admissibility criteria. Many applicants cannot be considered as victims when they contain, in general terms, measures affecting equally the whole population. Second, the court is compelled to clarify scope of Article 5 of the Convention. Does a general lockdown, including a restriction on freedom of movement of healthy individuals, qualifies as deprivation of liberty? That was one of the questions. How does the impact on the freedom of movement, assembly, and religion balances with the wider population's right to life? Third, the court had to address how this extraordinary situation impacts its appraisal on states' interference in the applicant's human rights and the prohibition of inhuman and degrading treatment. In particular, what is the court's approach on derogation under Article 15? Some states have formally derogated from the convention, and those are Albania, Armenia, Estonia, Georgia, Latvia, North Macedonia, Republic of Moldova, Romania, San Marino, and Serbia. And the second challenging question, how does the court address the rapid change on public services induced by COVID-19 pandemic? And now I will turn to addressing these issues one by one in some more details. First, the court has been keen to clarify that general complaints about COVID-19 related measures must be declared inadmissible based on the lack of victim status of the applicant. The latest illustrations of this line of a case law were applications originated from Croatia and Slovakia. These applications alleged in general terms that lockdown measures infringed almost all conventions' rights. And now I talk about Magdic versus Croatia and Lawrence and others versus Slovakia. In the court's view, the applicants failed to demonstrate that lockdown measures were likely to affect them directly or target them because of the applicant's individual characteristics. And here we talk about the standards laid down in the chamber case Zambrano versus France, even though the court in this occasion did not find it necessary to decide on victim status. The second, as for the scope of Article 5 of the Convention, the court found that general lockdown measures do not amount to deprivation of liberty within the meaning of the Article 5. We have Terhes versus Romania as the reference case. The fact that the applicant had been free to leave his home for various reasons and could not go to different places at whatever time of day and the situation required was decisive for such finding. Additionally, the applicant had not been subject to individual surveillance by the authorities and did not claim to have been forced to live in a cramped space, nor had he been deprived of all social contacts. Accordingly, the measures did not fall within the ambit of deprivation of liberty within the meaning of Article 5 of the Convention. Should the applicant successfully claim that her or his situation falls within the personal and material scope of the Convention right, the right of freedom concerned by the lockdown measures must be balanced with the right to life of the wider population. In the pre-pandemic world, the pre-pandemic case law, our court observed in an interstate application, Cyprus versus Turkey, and here I have a quotation that an issue may arise under Article 2 of the Convention where it is shown that the authorities of a contracting state put an individual's life at risk through the denial of health care which they have undertaken to make available to the population generally. 10 years later, in the case Stoyanovi versus Bulgaria, the court considered that authorities, knowing about the potential danger such as a naturally occurring hazard, are under an obligation to respond with due regard to protection of rights to life. In the context of COVID-19, the equal protection of the right to life, notably that one of detainees or asylum seekers of particular concern, due to the higher risk of contamination inherent to their living conditions. Between March 2020 and November 2022, the court processed around 375 interim measures requests related to the COVID-19 health crisis, mainly brought by persons detained in prison or kept in reception and or detention centers for asylum seekers. The court reiterated that Article 3 did not entail an obligation to move detainees in specific medical facilities. Thus, lockdown order within the detention centers are sufficient measures to ensure the health of inmates and personnel. And this is what we have in Fenech versus Malta, the case decided in 2021. In contrast, moving a healthy detainee to a facility where new arrivals of asylum seekers were being kept in COVID-19 quarantine is evidence that the applicant sustained degrading and inhuman treatment. In fact, a measure of placing the applicant for several weeks with other persons who could have posed a risk to his or her health in the absence of any relevant consideration to this effect cannot be considered as a measure complying with basic sanitary requirements. And this is the quotation from paragraph 92 of Fellatio versus Malta case. Regarding the third point, the emergency clause of Article 15, the COVID-19 pandemic seemingly falls under the natural and customary meaning of a public emergency threatening the life of the nation, defined as an exceptional situation of crisis or emergency which affects the whole population and constitutes a threat to the organized life of the community of which the state is composed. Here is the quotation from paragraph 28, Lawless versus Ireland, famous case. However, while the validity of the derogation under Article 15 was raised in Teres versus Romania, it was not decided upon. In Communauté Genevoise d'Action Syndicale versus Switzerland, the chamber noted that given the lack of declaration under Article 15 from Switzerland, the conduct of the Swiss authorities must be assessed in light of their ordinary margin of appreciation under the convention. It is noteworthy that this case is certainly subject to referral to the Grand Chamber. The court might have to examine further derogation under Article 15, as national court are themselves casting doubts in emergency declarations of their governments. Relying on the Strasbourg Court extensive case law on this matter, the Constitutional Court from Kosovo pointed out that any limitation of a fundamental right in the wake of a pandemic must occur in accordance with the law by the legislature constitutional review of decision number 115 of the government of Republic of Kosovo. On similar grounds, the Spanish Constitutional Tribunal dismissed the declaration on the second state of alarm as unconstitutional. And this is Vox parliamentary group of the Congress of Deputies versus National Government from 2021. Beyond the invasiveness of the impugned measures, the Constitutional Tribunal here feared that prolonged emergency prerogative of the executive could jeopardize the rule of law and the separation of power in Spain. Regardless of a state's formal declaration of Article 15 or the implementation of an exceptional domestic regime, the European Court of Human Rights has at first shown flexibility towards the states and applicants' conduct during the peak of the pandemic. The court found that the rapid change on working methods induced the lockdown measures should be taken into consideration while assessing the conduct of authorities. Accordingly, the impossibility of the applicant to appear in person during the immigration procedure in the early days of the lockdown, when authorities had to adapt quickly, could not be seen as an infringement of a convention. And we have paragraph 41 from Bach versus Netherlands from 2021. In the same context, the fact that an inmate was prevented from attending a religious service outside the detention facilities due to lockdown measures did not violate his right to exercise his religion. That was Spino versus Romania case. And concurrently, the court adopted a flexible approach of the admissibility criteria regarding the 6 months limit to lodge an application in case Saakashvili versus Georgia, paragraph 59 is of a reference, and C-Ed LCD versus Russia, paragraph 11. To conclude, I will now address the limits to this flexibility and the challenges ahead. In spite of its understanding of the complex situation faced by state authorities, the court has already found limits to its flexible approach. Firstly, the flexible approach should not be interpreted as weakening the state's obligation to execute the court's judgment. For instance, domestic violence increased exponentially owing to lockdown measures imposed in many European countries. A failure of the authorities to protect victims in these circumstances are evidence of violation of the prohibition of torture and inhuman degrading treatment enshrined in Article 3 of the Convention. And here we have a reference case to Nikova and others versus Russia. With regard to Article 6 and the right to fair proceedings in Q and R versus Slovenia, the Chamber found that COVID-19 related restrictions could not absolve the states of ensuring judicial proceedings in a reasonable time where urgent procedure remained available during the pandemic. With regard to Article 11 and the freedom of assembly, the Chamber found that given the gravity of the sanction and the fact that freedom of assembly was curtailed while restaurants and schools were open and the working from home orders were removed, the domestic court did not suitably review the proportionality of lockdown measures. And this was the case in Communauté Genevoise d'Action Syndicale versus Switzerland, which I cited previously. Concerns about sustained lockdown measures targeting specific parts of the population have been echoed by domestic courts. The Bosnian Constitutional Court found that the Constitutional Court of Bosnia and Herzegovina, found that the authorities infringed the applicant's right under private life, to protect private life and freedom of movement by imposing targeted restrictions on elderly and minors without reviewing less invasive measures and without limitation of time. So this is the case Leila Dragic and AB versus Government of Federation of Bosnia and Herzegovina. Further, the court's flexible approach is likely to be challenged in the future by the situations of asylum seekers amassed in a camp under lockdowns. Again, the question is whether the applicant situation in the camp constitutes a detention within the meaning of Article 5, and how a localized confinement in the camp while the rest of the nation is not in lockdown influences the intensity of the interference with the applicant's right and freedom. We have EB versus Serbia, which is communicated case, so to be seen. Finally, question arises as to how the court should assess a failure to notify demonstration in the context in which authorities might impose stricter requirements on demonstration in order to be able to manage the flux of people. So here we have communicated case Nemitov versus Russia, and we are going to see what the Strasbourg Court reply would be. So for the introduction, this is what I would like to share with you. I hope that I didn't take too much time. Thank you.
Thank you very much, Ivana. Considering that we are already late, I'll immediately give the floor to Arnfinn. Please, Arnfinn, you have the topic of limits of judicial scrutiny.
Oh, sorry.
Sorry. Limits of judicial scrutiny and the need for other effective mechanisms for review of the executive measures. The floor is yours. Thank you.
Thank you very much. A warm thank also to the organizers, and in recognition of the importance of the region and also of the forum, I'm very happy to be here for the first time, but still happy to be here. And I'm also convinced that the days that we will be spending together, I will learn a lot from them. And I'm happy to be here in Tirana and enjoying the hospitality and also the sun. Well, now the more serious stuff. As we had heard already this morning, the availability of effective judicial review of measures in fight of an emergency situation is of course crucial. However, and this is my issue, judicial review is still only one element in the panoply of control mechanisms that needs to be in function. My intervention, I will address certain important limitations pertaining to the judicial system, which have a bearing on its ability to exercise an effective control with administrative measures deployed in times of emergencies. And moreover, I will try to highlight some vital components of an overall democratic, broad-range system of checks and balances outside the judicial system. Allow me, however, first to start with recalling some key contextual characteristics with, well, the current health emergency, but also characteristics that might be transposable to other types of crises. First of all, I assume very often we'll be faced with a situation where a large part of the population might be in danger, which again, and Ivana highlighted this, triggers an obligation for the domestic authorities to take all reasonable measures in order to secure life and health. At the same time, the crisis impacts severely on society as such, on the proper operation of the public authorities and on economic operators. So the institutions entrusted with the responsibility to act for the protection of life and health may themselves be limited by the cause of emergency and might have to take precautions that limit their own ability to perform properly in fighting the emergency situation. The knowledge as to the cause of the crisis and the ability to predict its development and the efficiency of measures may also be limited. Policy choices will to a large extent have to be based on risk assessments rather than knowledge. And in doing so, the authorities will also to a large degree have to build on advice of experts. Access to reliable factual information and statistics is crucial in order to take informed choices. However, ultimately, the preferred strategy and choice of measures is not just only a matter of knowledge and science. It will also have to depend on a balancing between competing rights, interests, and values. And add to this that the emergency situation might evolve rapidly and in unpredicted ways, requiring swift reactions from the authorities, which indeed, of course, might have an impact on the quality of the decision-making processes. The need for speed may require that ordinary democratic processes are effectively set aside, for example, by the application of emergency laws or by other ways of circumventing, for the sake of speediness, the inclusion of checks and balances. There is, indeed, a serious risk in emergency situations of arbitrary or even abusive use of public power, also in the sense that the emergency situation becomes a pretext to introducing politically motivated measures against the opposition, against vulnerable groups. There is also a risk that measures that were initially justified are upheld too long. I leave this now, but this is, in my view, an important context of what we are now discussing. I now turn to what one might say, the limitations of judicial review, the limitations of the court's ability to perform effective control. And I would want to highlight certain elements here. First of all, again, the need for speed. Indeed, we all know that it is inherent in the judicial process that it takes time, even when it operates as expected. And then we also know that in a number of member states in the Council of Europe, throughout Europe, we have difficulties with backlogs, with the courts not being that efficient after all, under normal conditions, and then faced with the crisis, as we have been, of course, the ability to cope effectively with the crisis becomes even poorer. Of course, one tool would be the application of interim measures. And in principle, that might work, of course, again, depending on the courts being capable of providing access speedily also to this remedy. However, I think we have to realize, realistically speaking, that the threshold for any court, for any judge, in applying these kinds of interim measures will regularly be very high when it comes to actually stopping measures taken in order to fight, for example, a pandemic. Because you would have to make, again, a risk assessment, and most courts, most judges will hesitate to impose on the government not to introduce a measure if the risk for life and health is considered to be high, if the measure is not set into life. I believe we can see this reluctance playing out in the domestic judiciary throughout Europe, but notably we can see it very visible in the practice of our court, the European Court of Human Rights, when it comes to the application of Rule 39 of the Rules of Court. This is the court's version of the interim measures. There is a certain practice of the court interfering, you might say, but the general trend, and here perhaps Tim can fill me in, but the general trend in my reading is that the court is very hesitant in interfering with application of Rule 39 in order to stop general measures from being applied at domestic level. Another limitation, which is also of a general nature, but which is of course also present during a pandemic or a crisis, would be the costs of proceedings. Indeed, compared to the individual interest at stake, they might in principle be relatively limited, but when you add them, of course, it becomes important. But still, compared to the interest at stake, costs might certainly present a genuine obstacle for judicial review. And then we have a number of elements related directly to the very procedural framework that courts are expected to operate within, that will in principle also limit the court's role in a situation of emergency. Several have already mentioned the limitations as to who can bring a case to the court. I think this is quite widespread, that there are rather strict limitations as to what we in our court would call actio popularis. It's not just for anyone to go to a court and say, I don't like that measure. You have to prove that it has a real impact on your life. In our words, you have to prove that you are yourself a victim of that regulation. And we have a number of cases already in our court explaining these limitations, and I think we would be able to find parallels in domestic law more or less all over Europe. Moreover, we have to realize that those actually then being able to address the courts, reach it to the court, may not necessarily be very representative as to the interest at stake. And they may not even be able to provide the courts, domestic courts or our courts, with the material, the basis that the court would be needing in order to take a viable decision. This might be related to the facts, but this might also be related to the actual knowledge on the situation. And when a court is invited to assess the proportionality of a measure taken, it would normally also require that court or any decision maker to have a broader perspective of the whole set of measures taken, because actually this is where the balancing exercise is also carried out. What I'm saying is that some of the issues raised in an emergent situation might simply be too complex to be suitable to be decided by a court on the basis of the contributions by two opposing parties. Indeed, as we also have been explained, I think Darian referred to this, any court, notably also the European Court, can be abused in what would be a different political agenda, and in an emergency situation that might also be quite tempting for some. We have also to realize as judges that carrying out judicial review of administrative measures, the perspective will always have to be, well, in most cases, retrospective. And the court will normally leave a relatively large space of discretion to the authorities. These are inherent limitations in the judicial process. And also, finally, I think we have to realize that when courts decide cases also of this nature, the court will normally have to limit itself to decide the particular case, and will not be normally in a position to decide on what kind of general measures that needs to be taken. This is notably a political issue where most courts will not interfere. I also want to highlight two elements more specifically related to the role of our court in Strasbourg being an international court. And Darian already highlighted certain important elements, and others have also mentioned this, namely the subsidiarity principle, the idea that it is not for the international court to be in forefront when it comes to perform the judicial control with these kind of measures. This requires anyone that would want to apply to the court to exhaust domestic remedies first. This is extremely important for a number of reasons, not only because it actually is a general principle of law applicable to our court, but moreover, we need someone to establish the facts. We are not a court well equipped for finding the facts. And of course, in a complex factual situation like an emergency situation of any kind, our court is very poorly equipped in order to find what is actually the situation on the ground. This is for the domestic courts to sort out before the case comes to us. Secondly, the application of domestic law. This is notably also for domestic courts to figure out, not us. We are not entrusted with the responsibility of what would be the right understanding, interpretation, and application of domestic law. Then we come to the real assessment, balancing exercise between competing interests. And of course, the whole idea with the convention and the principle of subsidiarity is that that is best carried out domestically. You know the context, you know what is behind the difficulties that you need to solve. So first, when we have all this set up, then the court will then eventually possibly be brought into play. And it follows, probably from what I'm saying, and I'm quite sure that Tim will following up here, it follows that the role of an international court in the context of an emergency situation will be rather or relatively limited, seeing to it that the domestic decision-making processes are not arbitrary and that there are, as we are now discussing, sufficient checks and balances. It's not our job to second-guess the choices of domestic authorities with the benefit of hindsight. So this brings me to my next point, which is, of course, that with all these elements listed, and we probably could find more, coupled with the need for effective judicial control, there is also clearly a strong need for other mechanisms of check and balances with executive measures, and notably those of a democratic nature. And arguably, the need for these kind of mechanisms might even be increased in a situation of crisis. Let me highlight at least the following elements here. There will, of course, also possibly be more. But first of all, the Parliament. The need to involve the Parliament. The Venice Commission has highlighted that the involvement of the Parliament in the process of legislation allowing for intrusive, far-reaching measures is crucial. And although we have to realize that in a crisis it might be required to shortcut shortcuts when it comes to procedures and a simpler set of decision-making, there needs still to be some kind of control. Parliaments should always stay in power to control the actions of the executive authorities, and also doing that with reasonable intervals so that there is no doubt that also the parliamentary power is in play. And notably, dissolution of parliaments during a time of emergency would appear to be extremely dangerous. I include here also, of course, under this heading of democratic control, that carried out by ombudsman's institutions and similar, including national institutions for human rights. What I also would want to emphasize in particular would be what we in Strasbourg jargon would call the public watchdogs. I recall here that the court has always asserted to the essential role played by the press as exactly a watchdog in a democratic society. And it has connected that task of the press in imparting information and ideas on all matters of public interest to the public's right to receive exactly this information. Equally, I recall that although the press is the origin of this concept of a public watchdog, the court has also indeed recognized that NGOs play the same role. And equally, academic researchers and authors of literature on matters of public concern also enjoy a high level of protection. It is noteworthy also that the court has further said that given the important role played by the internet and enhancing the public's access to information, the function of bloggers and popular users of social media may be also assimilated to that of public watchdogs, insofar as the protection afforded by Article 10 of the Convention is concerned. I add that this role of being a public watchdog is associated with certain very important additional elements, just to mention them. This role notably goes hand in hand with duties and responsibilities regarding accuracy, reliability, due diligence, the principles of responsible journalism. And also, it needs to be mentioned that this role is supported by important principles developed by the court under Article 10 on the protection of journalistic sources, and notably on the right to access to information from public authorities. One might, for example, mention then access to information on what is actually the emergency situation and what are the nature of the means taken in order to fight it. Let me also finally mention here as one element the emerging case law on the protection of so-called whistleblowers. We have a pending Grand Chamber case, Halle versus Luxembourg, where we might expect the Grand Chamber to clarify at least some of the guiding principles when it comes to the protection under the Convention of whistleblowers. This case is not related directly to COVID at all, but I would assume that the principles will be rather transferable. Allow me then to sum up 5 very brief points. First, in emergency and crisis, there will be an increased need for checks and balances with the use of governmental power. Secondly, the crisis itself will regularly decrease the ability to carry out such checks and balances. Thirdly, control by judicial review may, because of the inherent limitations in the judicial process, when faced with emergency or crisis, show itself to be less effective. And fourth, democratic means of checks and balances becomes therefore, one might argue, even more crucial in times of emergency. And this is my fifth point. Accordingly, and notably in times of emergency, there needs to be a very high threshold, indeed, for accepting any measures that would severely limit the operation of these democratic avenues of checks and balances. Thank you for your attention.
Thank you, Arnfinn. Considering that this is your first time in Albania and first time in the forum, I was a bit tolerant. I gave you a bit more time than I should have. And I would not be so tolerant with Jovan and Tim, who have been before, both in Albania and in the forum. I'm obliged to. Please, Jovan, you have an interesting topic on the requirement of legality and provided procedure in accordance by law in the adoption of emergency measures. Please, the floor is yours.
Thank you, Mr. Chairman. I would like to welcome all the participants of this conference and express my pleasure to be a part of it. I decided to give my speech in my mother tongue, so now I will continue in Macedonian. Постапките за прогласување на вонредна состојба се посебно регулирани во националните законодавства на државите. Со прогласувањето на вонредната состојба може да се суспендираат одредени вообичаени функции на владата, може да се предупредат граѓаните да го сменат своето вообичаено однесување или може да се овластат владини агенции да спроведат планови за подготовка за опасност, како и да се ограничат или укинат граѓанските слободи и човековите права. Потребата да се прогласи вонредна состојба може да произлезе од различни ситуации, како што е вооружена акција против државата од страна на внатрешни или надворешни елементи, природна непогода, граѓански немир, епидемија, финансиска или економска криза или генерален штрајк. Вонредните состојби имаат две компоненти. Првата е законска рамка, која се состои од уставна и законодавна основа за вонредната состојба. Значи, како што кажав, вонредните состојби имаат две компоненти. Првата е законска рамка, која се состои од уставна и законодавна основа за вонредната состојба, и втората е оперативна рамка, која вклучува организациона структура и стратешки планови за справување. Should I continue in English?
We should check. We lost the English translation. I don't know the others.
Excuse us, we have a small technical difficulty. We need to restart the system. We had a small problem with one cable, and it will take us 3 seconds.
How long?
Okay, I will say the need to declare a state of emergency may arise from various situations such as armed actions against the state by internal or external elements, natural disasters, civil unrest, epidemics, a financial or economic crisis, or a general strike. States of emergency have two components: a legal framework consisting of a constitutional and legislative basis for the state of emergency, and an operational framework that includes organizational structure and strategic plans for dealing with emergency. Emergency legislation and measurements should be strictly temporary in scope. Declaring a state of emergency has certain advantages as it gives authorities the necessary powers to coordinate and implement plans aimed at protecting people and property during the emergency. In other words, during a state of emergency, the government has additional legal mechanisms at its disposal, that it has the right to pass decrees with legal force, which enables greater efficiency in managing the situation. Some rights, such as the right to life, the prohibition of torture, and principles of legality, cannot be derogated from even during emergencies and continue to apply. UN Human Rights Committee, in addition to the stated rights that cannot be derogated from, emphasizes that there are several other humanitarian provisions that must remain inviolable, namely human treatment towards all persons deprived of liberty, prohibition of taking hostages and illegal imprisonment, protection of the rights of persons belonging to minorities, prohibition of propaganda promoting war or national raising racial or religious hatred. Procedures guarantees indeed intended to ensure the integrity of the judicial system. There should be clear and accessible rules on when emergency measures can be introduced or when a state of emergency can be declared. These rules should be drawn upon before the declaration of the state of emergency for which they are being introduced. A declaration of emergency or emergency laws introduced outside the normal legislative procedure must clarify the legal and factual grounds on which they are based, the scope of the newly introduced powers, and the exact situations in which those powers can be used. Human rights restrictions as a result of emergency measures. Some rights, such as freedom of movement, freedom of expression, or freedom of peaceful assembly, may be subject to restrictions during a state of emergency. The requirement for predictability and clarity is particularly important. This may require the authorities to carry out regular communications with the public through various channels, including, for example, radio, television, internet, billboard placed in public areas, as well as parcel delivered to citizens by post in all official languages of the state, such as and in the languages commonly spoken in different areas of the country. These restrictions must, however, meet the following requirements. The first one, legality. The restriction must be prescribed by law. This means that the restriction must be contained in the national law in force at the time of application of the restriction. The law must not be arbitrary or unreasonable and must be clear and accessible to the public. There are several conditions that must be met for the restrictions of fundamental right to be in accordance with the law. There must be a legal basis in national law authorizing such a restriction. National law must be adequately accessible. National law must be precise and predictable. National law must provide legal protection against arbitrary interference by public authorities. The principles of legality and the rule of law require that the basic postulates of a fair trial be respected during a state of emergency. Only a court established by law can try and convict a person from a crime. In doing so, the presumptions of innocence must be respected. Other requirements are necessity of the restriction, proportionality, non-discriminations. All the restrictions should be interpreted strictly and may not be applied in an arbitrary manner. Authorities have the burden of satisfying restriction of the rights. At the end of this part, I would say that each member state can use Article 5 of the Convention, which allows it to take certain measures deviating from the obligations provided for by the Convention in the event of war or in the event of another public emergency that threatens the life of the nation. Now, I will move from the field of theory to practice. An application was submitted, which Darian Pavlich already mentioned. An application was submitted to the European Court of Human Rights by an association whose purpose is to protect the interests of workers and member organizations, especially in the area of trade unions and democratic freedoms. The application refers to the measures taken by the defendant state in the fight against coronavirus. I will not give specific data about the case because it is not final, but I will use it for the sake of a clearer presentation of the topic that I'm dealing with. Relying on Article 11 of the Convention, the applicant claimed that he no longer had the right to organize public meetings or to participate in such meetings because of the adopted decree by the government which prohibited public or private events with more than 1,000 people at the same time. Just a few days later, the World Health Organization declared the situation with the coronavirus a pandemic, after which the previously mentioned decree was replaced by a new decree on measures to combat the coronavirus, which declared the closure of schools, colleges, and other training institutions, and prohibited public or private gathering of more than 100 people. Immediately afterwards, a state of emergency situation was declared in the sense of the law on epidemics, after which all public and private events were prohibited. In the decree, criminal provisions were provided in case of non-compliance. Without going into a further elaboration of the case, I will mention a few questions that opened up before the court. Regarding the admissibility of the application, I will address two questions. First, whether the applicant has the status of a victim in terms of the provision of the Convention, bearing in mind that the Convention does not provide for the possibility of initiating an actio popularis for the purpose of interpreting the rights recognized in it. And if so, to what category does it fail? It means, is the victim a direct, indirect, or potential, and whether there is a direct link between the applicant and the harm he believes he has suffered as a result of the alleged violation. In this context, I will mention the case of Norris, Ireland, Open Door, and Dublin Well Woman, Ireland, and Otto Preminger Institute, Austria. Secondly, in the presence of emergency situation, whether and which legal remedies the complainant should have used before the domestic institutions, that is, which effective legal remedy was available to the applicant. In relation to the merits, in the presence of emergency situation where the restriction of certain rights provided for by the Convention is evident, in the concrete case, the exercise of the rights protected by Article 11, it should be determined whether the conditions of paragraph 2 of the said article are met, that is, whether the interference was prescribed by the law, inspired by one or more legitimate aims, and was necessary in a democratic society. Regarding the legal basis, I would like to remind you that according to the practice of the European Court, under the term prescribed by law, which appears in the Article 8 to 11 of the Convention, it is required that the disputed measure has a basis in domestic law, and the law that we are talking about in question be available and predictable in terms of its effect. In the context, I will mention the case of Kudrevicius and others, Lithuania. In doing so, domestic law must offer some protection against arbitrary interference by public authorities and the rights guaranteed by the Convention. As far as for the legitimate aims in terms of Article 11, paragraph 2 of the Convention, in this case, it would be the protection of health and the protection of the rights and freedoms of others. Finally, the principles that should guide the court in assessing whether the contested measures were necessary in a democratic society are set out in the already mentioned Kudrevicius and other cases in which the court, among other things, found that the freedom of peaceful assembly is one of the foundations of a democratic society, and it is subject to a number of expectations that require a narrow interpretation, and the needed limit, it must be convincingly established. The impunged interference must be viewed in the light of the entire case to determine whether there is a legitimate aim, whether it satisfies a pressing social need, and in particular whether it is proportionate to the aim it seeks to achieve, and whether the grounds on which call the authorities to justify it are relevant and sufficient. Thank you for your attention.
Judge.
Thank you very much, lady even. Dear colleagues, dear friends, it's a great pleasure to be with you again at the Rule of Law Forum, this time in sunny Tirana. As my colleagues have already indicated, this is one of the most important regular fora for judicial dialogue between our court, the Strasbourg Court, and the domestic courts. And as they've underlined, this forum is an important opportunity for us to hear and learn from you, the national courts who are first confronted with these issues and who by necessity bear the main burden of addressing them. And I'm very grateful for the opportunity and look forward to the rest of our discussions during the 2 days. As Lady has said, I've been asked to look at the concepts of proportionality and margin of appreciation, which in a large sense overlap with the presentation of my colleague Judge Bartson, and to some extent provide the theoretical underpinning to some of the things he said. Because the broader heading is democratic scrutiny of emergency measures, I will not focus on COVID-19, partly because the topic is broader, partly because, in fact, the court hasn't yet specifically addressed this issue in that context. I should also say that the topic of proportionality is very usefully addressed in page 230 onwards of the very helpful book on the protection of human rights during times of emergency, published by the Air Center and Civil Rights Defenders, which is in your pack. Now, as you're all aware, the concept of margin of appreciation, which is closely linked to the concept of subsidiarity mentioned by Judge Bartson, is now expressly referred to in the preamble of our convention. And it reflects in principle the fact that the Strasbourg Court will allow the state a certain margin of discretion when it takes or fails to take legislative, administrative, or judicial action in the context of a convention right. And importantly, the extent of the margin allowed will vary, sometimes significantly, according to the context, and the extent of the margin will have an important impact on the proportionality assessment that may fall to be carried out. The narrower the margin of appreciation, the stricter the supervision by the court of the proportionality of a particular measure. Now, this is, of course, not a new concept. In fact, its very first application was in the context of an asserted public emergency under Article 15 in the context of Irish terrorism, in the case of Lawless against Ireland as long ago as 1959. Some years later, in the case of Handyside against the UK, hence probably Lady's reference to the UK judge, the court identified the principle and explained it in these terms. By reason of their direct and continuous contact with the vital forces of their countries, state authorities are in principle in a better position than the international judge to give an opinion on the exact content of these requirements, as well as on the necessity of a restriction or a penalty intended to meet them. It is for the national authorities to make the initial assessment of the reality of the pressing social need implied by the notion of necessity in this context. As a consequence, the margin is given both to the domestic legislature, relating to the concept prescribed by law, my colleague Judge Ilewski just referred to, and to the bodies, judicial amongst others, that are called upon to interpret and apply the law in force. That said, of course, it does not give the contracting states an unlimited power of appreciation. The domestic margin of appreciation goes hand in hand with European supervision, a supervision that concerns both the aim of the measure and its necessity. And the supervision will cover both the legislation that underlies it as well as the decisions applying it, even one given by an independent court. Much more recently, in 2009, in the judgment of A and others against the United Kingdom, again in the context of a terrorist emergency, the court, the Grand Chamber, further confirmed and clarified two important aspects of the margin of appreciation. The first is that the margin of appreciation left to the authorities applies both to the question whether or that there is an emergency, as well as to the decisions how to respond to that emergency. In both cases, the margin will be a wide margin of appreciation, and the application of that wide margin was also more recently confirmed, not in an emergency context,
but in the context of healthcare systems and policy, in the judgment of Wawrzycka against the Czech Republic, referred to by my colleague, Judge Seibert 4, this morning, a case concerning statutory vaccination of children. The second important clarification is that the margin of appreciation is essentially a concept that applies in this form only between the member states of the Convention in all their forms and the Strasbourg Court. While the separation of powers in the domestic system will most likely also require the domestic courts to give some deference to the other two branches of government, once a domestic court has held that an act of the legislature or the executive was disproportionate, the Strasbourg Court will be highly unlikely to entertain any argument by the respondent state before it that the domestic court should have allowed the executive or the legislature an even wider margin of appreciation. Looking then to the concept of proportionality, again, I will focus more broadly rather than specifically on Article 15 concerning derogation in times of emergencies threatening the life of a nation. You all know, of course, that the basic concept of proportionality is the need for a fair balance that needs to be struck between the demands of the general interest of the community and the requirements of the protection of the individual's fundamental rights. In this context, the court has taken a slightly differential approach between how to assess the proportionality of general measures and their application in individual cases on the one hand, and of individual actions or decisions on the other. Of course, in the context of emergencies of the type we are discussing today, we are most frequently, if not invariably, confronted with the former, that is, general measures, and their application in an individual case. In that context, concerned with measures such as general legislation, the court has confirmed that it will primarily assess the legislative choices underlying it in doing so, and in doing so, the quality of the parliamentary and judicial review of the necessity of the measure is of particular importance. It is also relevant to take into account the risk of abuse if a general measure were to be relaxed, that being a risk which is primarily, again, for the state to assess. The application of the general measure to the facts of a particular case remain illustrative of its impact in practice and is thus material to the assessment of proportionality, but is unlikely to be decisive. In the context of the mandatory vaccination of children considered in Wawrzycka, the court considered that the following factors rendered the general scheme in that case proportionate. One, the vaccination duty was considered effective and safe by the scientific community. Two, albeit compulsory, the vaccination duty was not absolute and it allowed for exemptions, either on grounds of permanent contraindications or on grounds of conscience, which were subject to a rigorous assessment of individual circumstances. Thirdly, the duty was enforced indirectly through the application of sanctions, which in themselves were relatively moderate, consisting of one-off administrative fines. Fourthly, there were procedural safeguards of both an administrative and judicial nature. Sixthly, the legislative approach employed made it possible for the authorities to react with flexibility to changes in the epidemiological situation and to developments in medical science, and therefore the measure was not permanent or inflexibly fixed. Seventhly, the integrity of the policy-making process and the transparency of the measure by the domestic system. And finally, with regard to safety, there had been no reason to question the adequacy of the domestic system for the monitoring of the safety of the vaccines in use and the checking for possible contraindications. Interestingly, though, having looked at all these procedural aspects of it, the court noted that all generally, in individual cases, the availability of compensation in the case of injury to health caused by vaccination was relevant to the overall assessment. This issue could not be given any decisive significance where no vaccines had, in fact, been administered. So the fines were imposed before vaccination was given. When assessing the proportionality of the impact of the policy on the individual, unvaccinated children who were, as a consequence, refused access to preschool, the court concluded, and I quote, that it cannot be regarded as disproportionate for a state to require those for whom vaccination represents a remote risk to health to accept this universally practiced protective measure as a matter of legal duty and this is the first time it has been expressed in these terms, in the name of social solidarity for the sake of a small number of vulnerable children who are unable to benefit from vaccination. Finally, when the complaint is that a state has failed in its positive obligations to protect an individual, in this context, for example, a detainee, in the context of emergency situations such as the COVID pandemic, the court has reiterated that preventive measures have to be proportionate to the risk at issue, and that they should not pose an excessive burden on the authorities in view of the practical demands of imprisonment. This is even more so where the authorities were confronted with a novel situation, such as a global pandemic, unprecedented in recent decades, and as a result of a new strain of coronavirus to which they had to react in a timely manner. That's just to set out the scene and hopefully stick closer to the time I've been assigned by those who charged me with making this presentation, and I look forward to our discussions. Thank you very much.
Thank you very much, Tim. Thank you all for your presentations, which indeed complement each other and set out the framework to be followed by national judges in dealing with these issues. Now the floor is open. Questions, comments, experiences from national courts, national authorities on the issues that were raised during this panel. I see also Ivana is online. This is perfect. Thank you very much, Ivana.
Can I just say a word?
Of course.
I'm sorry.
Of course.
Yeah, I would like to actually inform all of you, but you know already, and Biljana knows, I have a meeting at 3:15, which had been already envisaged. So I cannot stay more than a couple of minutes, and I hope for your understanding. But you already, changed the agenda of today, and it is not easy to, combine, daily obligations with online participation. I'm sorry for that, Thank you.
Thank you. So, questions? Please. Yep. Please introduce yourself.
Thank you, lady, Judge Bianco. Thank you to the members of the panel for their insights. And also I would like to thank the AIR Center for having organized this event for us and that brought us here in Tirana. I don't have a question. I rather would like to underline here the fact that, as was mentioned in the morning panel by Judge Pavli and also at the outset of her remarks, Judge Ivana, that our court was activated by one of the authorized parties on the matter of restrictive measures issued by or introduced by the government at the very beginning of the pandemics, when the situation was rather unpredictable. The court was asked, or the decision of the government indeed was challenged in terms of its constitutionality, grounded on the fact that the decision as such, as an executive order, was not in line with the Constitution, since the restrictions it provided for were not stipulated under the specific law, and that the laws that the decision was referring to were not precise in their provisions regarding the limits that were set to certain rights, namely the freedom of movement and the freedom of assembly in public and private environments. So basically, what we reviewed in terms of the request brought before us was whether the decision of the government met the criteria set under the Constitution as regard to the limitations of rights. So basically, the court came to the conclusion that the ruling or the decision of the government had not been based on the law as provided under the Constitution. However, we, given the circumstances and given the fact that the matter was very new and the pandemic was at the very beginning, we basically said that the decision as such does not meet the constitutional requirements since it is not grounded on the law, and as such it has to be abolished. However, we gave, in our view, enough time or reasonable time to the Parliament to enact a law that would specifically authorize the state agencies how to act under the pandemic circumstances, and to make sure that any restriction that would be enacted would comply with the constitutional guarantees. And therefore, as a result of that, the Parliament acted relatively swiftly and adopted a law that basically set in place the limits or the framework authorizing the state agencies to act as necessarily under the pandemic circumstances. Thank you.
Thank you very much. Other interventions from the participants, please. Yep. Brief, please.
Yeah, sorry, short this one. Just to introduce myself, I'm Siniša Beković, Ombudsman of Montenegro. I'd just like to comment a few things that happens in Montenegro, but I think it was a common almost all over Europe. Firstly, I think that three of those principles we are discussing about when speaking about the limitations of human rights: legal basis, legitimate aim, and especially proportionality as the part of the third one. It was not present at all, not in Montenegro, I think, and not in so many countries. Our legislation was not completed, and I've heard what our agent said, just to say that the criminal sanctions were imposed only because there was no other sanctions. The administrative sanctions has been introduced only after the intervention of Ombudsman of Montenegro, when we made a certain analysis of the, let's say, criminal sanctions all over Europe, and when we understood that our sanctions was, for instance, 4,500 euros, it was, I think, the biggest sanction that we heard about, not to be imposed to the perpetrators. The only certain thing, it was a legitimate aim. So it was the fight against the, let's say, pandemia. The third one, I think it was the main challenge, and it is not the challenge as I may seem, as I feel. It was not only the challenge for the Montenegrin authorities, but I think for almost all the authorities in Europe, as well as for the European Court. So my problem to understand is because we didn't know anything about the pandemic, especially not about the virus. And for the number of times I tried to convince the people in Montenegro, especially those stakeholders, that the scientific approach must prevail. in many of those circumstances, especially speaking about the people who were imposed those sanctions, was not aware about the situation at all. So they were simply not prepared for the situation in general. So we did not have so many, how to say, informative, let's say, materials, documents. The TV was not in this way present in the public because everything was under the, let's say, a certain curtain. And I think it was also the proof that the social ground where the law should be applied was completely absent at the time being. My last, and I think it would be also a question to you. We discussed a lot about whether the state emergency is the solution, or we can make something also with the so-called, how it's called, an extraordinary situation. So I think that we spent a lot of time, and this is for many reasons. Just to ask you, what's the experience, what's your experience? As I know, only about 11 countries has declared, let's say, the state of emergency, and the others did not. What your experience is? Was those, let's say, samples of the countries with the state of emergency more helpful than the others? Or the better, was the state emergency the best answer to the situation that we had?
Much. Unless there are other questions, I might give the floor to the members of the panel to give their opinion in general and also to the question that was just asked.
If I may, just a brief reflection as to the last question, as to whether it would be wise or advisable to apply Article 15, or whether you can apply the more general approach under the Convention when faced with such a situation. I think what we can infer more or less very clear from the fact that some member states applied 15 and some did not, that this situation, there is not one answer to this. I think it depends a lot on the particular context, and there is also different ways of assessing the need to be on the safe side in advance, because I think that was the idea with applying Article 15. I think what was the approach taken by a number of member states, including my own Norway, was that they had the trust that the court and also themselves would be able to apply the flexibility under the Convention without actually going the further step, applying Article 15. And I think so far our case law and our experience, both as again in Norway, but also in our case law at the court, I think it shows that that was actually an okay assessment. There is a large flexibility in the Convention system, and the system can be applied also in situation of stress, actually, without triggering Article 15. I think that's the outcome. But I wouldn't say it was either that was a mistake or the other. I think it has to do with the approach taken domestically, and the Convention allows that.
So I think I would just echo that. I mean, one of the fascinating things is that COVID, I think, has led very promptly to the largest number collectively of uses of Article 15. But looking at our case law so far, it's actually not clear yet whether that was helpful or not, and whether actually our assessment would be different in the context of Article 15 or not. So to some extent, it's probably more of an expression of political, often referred to trust in the courts, but a political statement rather than a legal statement. And you will know the one case I think that was referred to this morning in relation to Romania, where the issue did arise, the court didn't actually have to rule on the Protocol 15, on the Article 15 derogation. I just wanted to make an observation to the description of the case in the Kosovo court, which I think reflects very well the different position you find yourselves in and we find ourselves in. Because, of course, as a constitutional court, you have the power to say, this is unlawful, it's not in accordance with the law, but we will maintain the power, having reviewed it, having considered it proportionate, having considered it necessary. You can maintain it and therefore give it a legality, which I doubt we would ever challenge. If the matter came to us direct, of course, Usually it's much later, but we also wouldn't have that power. We would be much more confined, I assume, to looking at, is it in accordance with the law? Well, it isn't. Actually, do we get to proportionality analysis? So that's, I think, why this dialogue is important, and I think, the margin of appreciation, subsidiarity, which we were talking about, is so essential, because also you're finding on why you maintained it in place while Parliament worked out a solution will be the essential information for us to assess, was it necessary, was it proportionate in the context in which it arose.
Just one sentence. In this context, I would like to mention the case Alpay versus Turkey and Mehmet Hasan Altan versus Turkey. What is interesting in this case? Here there was a derogation under Article 15, but still the legality criteria were taken into account from the European Court. Thank you.
The court, I think, started since lawless with the examination of the derogation measures. So in the very first case before the court, that was the kind of exercise. If there are no other questions, comments, I think we can conclude this session. I thank very much the participants in the panel for their contributions and their reactions, and also Ivana, who was online. And I thank you all for your attention and the participation. And now Biljana has an information for the follow-up.
Yes, just for the next steps. So we'd like to invite you for a coffee outside, and then the last session that will last a bit shorter than initially planned will take place in 3 rooms, and you will see on the board outside that we have divided judges and institutions in 2 groups. Group 1 will stay in this room. Group 2 will go back to the main building, and there will be people taking you. Group 3 is, as per agenda, the non-governmental organizations. They will go to a 3rd room, and we will take the judicial training institutes to talk to them about project activities. But for groups 1 and group 2, that is judges of the European Court, domestic judges, ombudsman. If you can please look at the list outside, and the group 1 is here, group 2 is outside. Good. Excellent.